Okay, Ms. Bailey Quick, you're here on behalf of Miss, is it Nykiel?
Yes, Your Honor.
Okay, and it looks like she's connected. We'll go on the record in Nykiel versus Nykiel. This is case number 2419729. Ms. Bailey Quick is present along with the plaintiff by Zoom video. I don't see the defendant, Mr. Nykiel, present. Ms. Bailey Quick, have you had any contact with him at all?
I know my staff has tried to reach him today. He did participate in mediation. We did reach a resolution, so I was expecting him to be available. I know he's not exactly technologically savvy.
Okay, well, I haven't received the mediation report indicating that the case did settle. So how did you want to proceed today?
We don't have a signed judgment, so if the court has availability, I'd like to get a judgment entered. So if the court has availability on the next docket day, I would like to perhaps set it over and that would be my request. Charity, do you think perhaps maybe you could get a hold of them and if maybe we can come in person, Your Honor?
Are you talking about today?
No, on the next available day. He
Yes.
does not do technology well. We did do mediation in person. Didn't we? Did we do it in person?
Yes. Yeah,
Okay,
you and I did. Yep.
Okay, yeah, I mean, I don't have any objection to setting that in person if that'll make it easier. I might be able to schedule this for a hearing on my mid-November motion day, which would be, in about 2 weeks. My docket's been fairly light for that day generally, so do you think you'd be ready that quickly?
I've had a judgment prepared since September, so if Charity can help facilitate getting him communication with him. I know we've tried, but I think he responds better with her. I know it's probably not her favorite, but
All right, I'll set it for an in-person hearing. I'll ask Jennifer if we have room in the docket for the mid-November motion day. Since all my hearings that day are generally in person anyway, so I'll have a court officer already in the courtroom for that. And if not, then it'll just have to be on the full motion day in December, but I'll try for that mid-November date. And we'll go from there. Anything else I can address for you today, Ms. Bailey Quick?
no, Your Honor, thank you.
Okay, thank you. You're free to disconnect at this time.
Thank you.
For a final status conference?
Final hearing.
Final hearing, okay.
Okay, we've got both counsel connected. We'll go on the record in Trevor versus Bonnell. This is case number 2319554. If I could have both counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Elliot Blumberg on behalf of the plaintiff, Joseph Trevor.
Paul Slough on behalf of all the defendants.
Okay, this is set for a status conference today. Mr. Blumberg, can you kind of tell me where things are at from plaintiff's standpoint?
Yes, Judge, we completed a rather lengthy mediation session that was not successful, but out of it has come some discussions. We are in the process of getting a second business valuation as provided for in the operating agreement in this case. I don't know if you have some recollection of the facts of the case. So we're in the process of obtaining that. Unfortunately, the way the operating agreement reads, that if the second business valuation is different than the first, then there's a third business valuation that has to be completed. So it doesn't look like at this point the end is really in sight, although Mr. Slough and I have gone back and forth over some potential settlement discussions, none of which have reached fruition at this point.
Okay, Mr. Slough.
Yeah, that's correct. My clients are frustrated because Mr. Trevor's had a number of months now to have this other valuation performed, and is now just evidently getting someone retained to have it done. I would just ask the court impose some sort of deadline so that we're not waiting indefinitely for it to happen, whether it be 2 months, something like that. I mean, I think that would be very reasonable.
Mr. Blumberg, any thoughts on what an appropriate time frame would be to have that done?
Yes, Judge. Adam Evaluations out of Grand Rapids is going to be doing it, and they've guaranteed it can be done within 90 days. So I don't think 60 is. I don't want to be held by that and not have it done in time.
Okay. All right, the court will set a deadline for that valuation to be completed for 90 days. I'll also set it for a status conference at that 90-day mark. And we can determine how we want to go forward from there in terms of scheduling. Mr. Blumberg, any other dates that I can address for your side while we're on the record here today?
I don't think so, Judge. Yeah, I don't believe so.
Mr. Slough?
Judge, the valuation really speaks to our counterclaim, which is to require Mr. Trevor to sell his membership interest to the other members. There's still this credit card issue outstanding. I don't know that my clients want to do a whole lot of discovery on it, but I guess my question is discovery going to remain open for the 90 days or is it just for the valuation?
No, I mean, I think I'll leave discovery open at this point because that may raise some issues that the parties want to explore. So I think for the next 90 days, at least, the discovery will remain open. Mr. Blumberg, do you have any objection to that?
No, that would be appropriate. Thank you.
Okay.
Thank you.
Beyond that, anything further, Mr. Slough?
I have nothing further.
Okay. All right, I'll put this into an order. The court will also send out notice of the date and time for that next status conference, and both sides are free to disconnect. Thank you.
Thank you.
Good luck to everybody.
Yeah, thank you.
Okay, let's see here. Mr. Galdis, are you here on behalf of the defendants in Smith versus Bauer?
Yes, that's correct, Your Honor. Attorney Stan Galdis for Straub, Seaman, Allen, PC, and Matt Tompkins.
Okay, and I see Ms. Smith is connected. I don't see her attorney, Ms. Bailey Quick. So let's just hold on for a minute. She might be just having trouble connecting or something.
Certainly.
And I have another hearing scheduled at 2, so I'm going to take that one while we're waiting for Ms. Bailey Quick.
Very good, Your Honor.
Hi.
Okay, ma'am, on the Motorola device, are you Renee Rapley?
Yes, sir. Yes, Your
You
Honor.
are. Okay, great. Let's see, I think the other party in your case is connecting. Okay. Are you Luke? Is it VandeKerkove?
VandeKerkove, yes.
VandeKerkove.
Okay. All right. This is file number 2419803. The record should reflect both parties are present by Zoom video. This is set for a pretrial scheduling hearing in this divorce matter. This is a time when the court tries to determine whether or not there are any issues regarding the division of any marital assets or debts that the court needs to decide, or whether you two have been able to reach any kind of agreement. So, Mr. VandeKerkove, where do you stand? Where do things stand from your standpoint in terms of dividing up assets and debts of the marriage?
All I would like is the 2007 Honda Pilot that we, besides that, that's all.
Sorry, you're breaking up a little bit there. Can you repeat that?
I would just like the 2007 Honda Pilot, and that is all that I would like.
All right. Is that something that you've talked to Ms. Rapley about?
We've attempted to talk about it, but nothing has been agreed upon.
Okay. Ms. Rapley, are you indicating you don't want to agree to that?
I will not agree to that. No, Your Honor, I do not agree to that.
Okay. All right. So when the parties aren't able
I
to
have
reach
never agreed to.
Okay, that's fine.
I can't hear you. What did you just say?
I said when the parties aren't able to reach an agreement.
I don't like this Zoom.
Ms. Rapley, can you go to one spot and stay there for me?
I'm moving closer to my Wi-Fi because you're breaking up. I'm sorry.
Okay.
Sorry, you were breaking up. So both parties, they don't agree. That's where I got.
Okay. So when both parties can't agree on how to divide things up, then we go through a process called mediation. That's where the two of you will meet with a neutral third party. Neither of you are required to reach any kind of agreements, but that third party will they're trained in trying to facilitate an agreement. So they'll talk with both of you. If you can reach an agreement, that's great. And we can set it for a final hearing after that to finalize the divorce. If you're not able to reach an agreement, then I'll set it for a hearing for the court to take evidence and testimony from both of you, and then I'll make a decision about any disputed items of debt or assets. Ms.
Okay.
Rapley, do you have any questions about that?
No, Your Honor.
Mr. VandeKerkove, do you have any questions?
I have no questions, just a concern about mediation. We've tried multiple times over the past 3 months to come up upon an agreement, and she's not wanting to work with me on anything.
Okay, well, like I said, neither side is required to reach an agreement. The mediators are trained in trying to facilitate an agreement between the two of you. So that's different than what you've been trying to do on your own. And so that process may work, it may not work. And if it doesn't, like I said, then the court will make a decision.
Okay,
So I'm going to refer it to the community mediation. They will be in touch with both of you to set up a time that works for each of you to do the mediation. You're both required to participate in that in good faith. In other words, you have to attend and you have to at least make a good faith effort to reach an agreement. So as long as both of you does that, again, if you're not able to reach an agreement, that's fine. But you're required to participate in the process. So Ms. Rapley, you can't just decide you're not going to participate. You have to at least try, okay?
Yes, Your Honor.
Okay, so they will be contacting you to set up a date and time. You need to make sure, both of you, that you respond to community mediation when they contact you. And then I will set this for another hearing following that. And we'll go from there. I will put that into an order. You'll also both get a copy of that. And that's all I have for today. You're both free to disconnect at this time.
all right, thank you, Your Honor.
Thank you, Your Honor. Have a great day.
Your Honor,
Okay.
all this, I don't see that plaintiff's counsel has appeared yet. Would you like me to try giving her a call on the number via the pleadings?
Well, let me just, I know that the parties have been kind of waiting for a probate matter. Can you just tell me whether that is concluded or not yet?
I don't represent the plaintiffs. I don't have any understanding as to whether or not the probate matter has completed, Your Honor. Maybe Ms. Smith has some additional information.
All right, Ms. Smith, have you been in contact with Ms. Bailey Quick about this case?
Not recently, Your Honor. Her office
Okay.
sent me a reminder for this meeting today, and I did just shoot a text her way, but haven't received a response.
Okay. All right, well, I can't really do anything more for the purpose of today's hearing. So I'm going to set this for another status conference. And Ms. Bailey Quick has appeared on a couple other different matters today, so I'm not sure why she's not here on this one, but she's usually present and ready to go, so I'm not going to hold that against her.
I do know, Your Honor, that another, it may have been through the probate court, was postponed about 2 or 3 weeks ago. So maybe because that matter has not been concluded, I'm not sure, to be honest with you.
Okay. Okay, well, I'll send out a notice of the date and time of the next hearing. And Mr. Galdis, anything further you wanted to state for the record today?
No, Your Honor, that sounds agreeable to our office. Thank you.
Okay, thank you. Both sides are free to disconnect at this time.
Thank you, Judge.
Okay. 2:15 got canceled. So.
Oh, did it? I didn't see.
Okay, council, we're a little bit early, but since you're both connected, I thought we could get started. This is Meer versus Al-Colani, case number 2419786. And if I could have council put your appearances on, starting with plaintiff, please.
Amanda Danielewski for the plaintiff.
Gary Anchors on behalf of the defendant.
All right, we're set for a pretrial scheduling conference in this case here today. I know just glancing through the complaint involves employment-related claims. Ms. Danielewski, can you just tell me a little bit about your case and what you'd like to see for scheduling going forward?
Sure. This is an age discrimination and retaliation case. And after we filed, Your Honor, we learned of the existence of an arbitration agreement. The arbitration agreement was executed via DocuSign. And as I'm sure you're aware, my client didn't recall doing it because as employees, we just click and sign. And Mr. Anchors was kind enough to show us all the background documents and that kind of thing. And so our intention, I believe, Mr. Anchors can confirm that I believe we're going to send the court a stipulation, but we're also trying to resolve the case. At least we're going to give her a shot before we initiate the arbitration. So we were hopeful to get closing papers to you within 30 days, either advising that we're going to proceed with arbitration or just a simple stip in order to dismiss, depending on where we go with negotiations.
Yes, that's correct. Ms. Danielewski and I have had cases over the years, and we actually work pretty well together. And I provided her with some additional documentation regarding the arbitration agreement, and we've communicated over the last several days, Your Honor. In my intention would be that we would file a stipulated order to dismiss without prejudice so that the court could have jurisdiction to enforce any arbitration award if we get to that point. But frankly, a demand has been made, and I've been in contact with my client to see whether or not we can resolve this even short of going through an arbitration proceeding.
Okay, all right. I'm just going to indicate then for purposes of the scheduling order that further scheduling is not needed, that the parties will submit either, a stip in order to dismiss or some other closing document.
Can we say 45? Can we say 45 days, Your Honor? Simply because I know already November 1st, it's hard to get a hold of anyone with the holidays coming up, and I'm just trying to build in a little time to get everyone lined up to see if we can get this thing resolved before then.
Yeah, certainly. I mean, I was going to say, I'm going to set this for a status conference at 90 days out.
Okay, that's great. That would be wonderful. Yeah.
This is a control date for me so that I don't have this sitting out there without a next date. And then that gives us an opportunity to check in if something goes awry.
That would be wonderful.
Okay. Anything else I can address for either of you while we're on the record today?
No, thank you for.
No, thank you, Your Honor. We really appreciate that. And we hope to have this thing put away once and for all. So we appreciate it.
Okay, thank you. That's all for today. And you're both free to disconnect.
All right. Thank you. Bye-bye.
All right, looks like we've got all counsel connected, so we'll go on the record in Jones versus Munson. This is case number 2319251. And if I could just have counsel put your appearances on, starting with plaintiffs, please.
Good afternoon, Your Honor. Jennifer Sikorsky on behalf of the plaintiff.
Rebecca Walsh on behalf of the plaintiff, also, Your Honor.
Ralph Valatutti on behalf of Doctors Kylie, Jonette, Murphy, and Minor.
Good afternoon, Your Honor. Jenna Wright Greenman appearing on behalf of the hospital et al.
Thank you. The court has this set for a status conference today. I know we've had some motion practice, and I believe, perhaps correct me if I'm wrong, but I believe we do have a motion set for December. So I don't know that there's anything, maybe this got set before this as a status conference. I don't know that there's anything that we can really address today other than just going forward with that motion as scheduled next month. Maybe Ms. Walsh or Ms. Sikorsky on behalf of plaintiff, tell me what your thoughts are for today's purpose.
Yes, Your Honor. I think that what you probably have on your desk are the motions for partial summary disposition / Daubert hearings. And I did have one question about those. I believe the defendants filed 2 motions and we filed 3, and we were giving 2 different hearing dates on those. And I did wonder if you wanted to have them all heard on one day. We have facilitated the case. It wasn't successful. We're prepared to go through with these motions, and then I think motions in limine and getting a trial date are really what we are what's next for us, Your Honor, and we're ready and prepared for that.
Okay.
So, Your Honor, as I read the court's orders, we have dispositive motion cutoff, which was Friday, and we filed our dispositive motions. And at this point in time, there is not a deadline for the filing of motions in limine, and we have a few to file. So I guess what plaintiffs filed some motions in limine. Is the court going to set a deadline for the cutoff for filing motions in limine?
If I could clarify, Your Honor, we filed Daubert motions. Those were the motions that we filed, not our motions in limine. Those have not yet been filed.
Okay, all right. I've not set a cutoff date. I normally set the cutoff date for motions in limine closer to a trial date. What I'll do once we get to that point, after the current motions have been heard, is the court will set trial dates, and then I set what I call a trial preparation conference about 30 days prior to the trial date. And that typically acts as a cutoff for motion in limine. So the parties aren't to that point yet, and you're all still free to file those kind of motions that are filed in preparation for trial. And then at that conference, we talk about just kind of the nuts and bolts and procedure of how the trial will go so that everybody's on the same page by the time we get to the morning of the trial. So that's a little bit off now into the future. Ms. Greenman, you haven't had a chance to jump in here yet. Did you have any input based on what's been said so far?
I do not. Thank you for asking, Your Honor, but no, I think both parties are on track with what they've conveyed thus far. Okay,
so I guess rather than trying to change hearing dates, and I don't have those dates right in front of me, but to the extent that the parties have motions filed and set for hearing on different days, I'd rather just let's just go forward as scheduled. And then whichever is later in time of those motion hearings, at that later motion hearing date, we can set a date for that trial preparation conference and talk about trial dates at that time. So I guess for today's purposes, in terms of the scheduling order, I'm just going to indicate that we'll proceed with motions as scheduled, and the court will set a status conference for the later of those motions so that we can address that on that same date. Ms. Walsh or Ms. Sikorsky, do you have any objection to having that as kind of a plan for going forward from today?
I don't, Your Honor.
Yeah, we don't, Your Honor. I would mention that we are renoticed one of our motions. We got a hearing date from you of December 16th or 15th. Yeah, 16th. But we did see the defendant's motions come in as we were just before we filed ours. So I think one of ours we notice for hearing on the date of the defendants, even though the date we got when we called was a different day. So we may have already submitted a renotice of hearing so that all three of our motions will be heard on the 16th.
Okay, all right.
Okay,
And
and we
that's
don't
fine.
have anything else. Thank you.
Mr. Valatutti, anything further from your standpoint?
No.
Ms. Greenman?
No, Your Honor, thank you.
Okay, thank you. That's all I have for today, and all counsel are free to disconnect on this file.
Thank you, Your Honor.
Thank
Have
you.
a great
Thank
week.
you.
Thank you, Judge.
Good afternoon.
Hello. Let me just make sure we get everybody connected here. All right, we've got everybody connected, so we'll go on the record in TBF Financial versus 45 Degree Hospitality and Bach, case number 2319505. And if I could just have counsel put your appearances on, starting with plaintiff, please.
Thank you. Good afternoon. Daniel J. Fico appearing on behalf of plaintiff TBF Financial LLC.
Scott Norton appearing on defendants 45 Degree Hospitality Inc. and Dean Bach individually.
Judge Francis Belzer Wilson. I represent the federal court appointed receiver, M. Shapiro Management Company. The case's status as it relates to the receivership, but I received a notice to appear, so here I am, Judge.
All right, thank you. I appreciate that. All right, we did have this set for a status conference last month. I think there was some kind of mix up. Mr. Norton was not present, so I reset it for today. In terms of going forward, Mr. Fico, can you kind of tell me where things are at from the plaintiff's side?
Well, we've unsuccessfully tried twice now with the motion for summary disposition. When we were last before Your Honor, the opposing counsel had indicated that he anticipated filing motions of his own, that he believed there were defenses, and that he was expecting to see some kind of a dispositive motion from his side, but I haven't seen anything yet. I would imagine we're well past the dates for filing any such motions.
All right, thank you. Mr. Norton?
Well, yes, and we have the counsel present at this hearing today who represents the receivership in the federal court action. And as I've put forward before, that I believe that even though Mr. Bach is not covered by that receivership order, the initial liability, which runs to 45 Degree, a corporate entity that is covered by that receivership order, is one that begs the court for us to take a close look at whether this case could even go forward. And we talked about that, but there has been movement in the federal court action with respect to corporate assets and kind of changed the landscape of what we're proposing. And so this is, if I understand the court's instruction, this is a status conference as to where we're going to go from here. And so, yes, the motion to include Mr. Bach in the stay is something that we would like to pursue. The federal court action, and Ms. Francis, she's here, is kind of a moving target because properties are being sold and things are going down. So one of two things, let's go forth and litigate, or two, this court should take serious consideration to staying this action, because quite frankly, it's 45 Degree is the one that signed. This is a $25,000 claim with respect to a stereo system or something of some similar substance, okay, which is allegedly guaranteed by Mr. Bach. But when you look at the federal court case and the corporate entities that are a part of that case, and Ms. Miller can speak to that as well. It's inappropriate for us to go forward at this point. However, in trying to fashion a motion, with respect to a stay with respect to Mr. Bach, the federal court case is a moving target. It keeps moving on us. And so well, one, this is a status conference. So let's talk about where we're going to go next. And perhaps you would like to have a comment or two, Ms. Miller.
No,
No.
I don't think Ms. Wilson has anything that she
Ms.
probably
Wilson.
needs.
Ms. Wilson.
So I guess, yeah, go ahead, Ms. Wilson.
No, I mean, I don't have the order directly in front of me. The case is stayed as to, I believe, 45 degree hospitality in this matter. But the federal court order, which was submitted to Your Honor and your court, sets forth in regards to the stays against any lawsuits against the receiver or the property that was at issue in the federal court. So, Your Honor, Mr. Bach isn't specifically outlined in there, and the receiver takes no position on how this court proceeds in that nature.
Okay. All right. Well, Mr. Norton, I mean, you said this before, and you keep telling me I need to take a close look at it and so forth. But it's your job to file a motion to get it in front of the court. So you just telling me I need to take a serious look at it, which you've done several times, isn't making the case move along. Plaintiffs are filing motions, they're trying to prosecute their case, and you need to do the same. If you believe you have a defense that gets Mr. Bach out from under this case permanently or temporarily, it's incumbent on you to file a motion and get it before the court. And so you're right, we're at a status conference, but you know, every time we have a status conference, you mention these things, but you're not filing anything. So I'm going to give you a deadline today as part of the status conference. And you're either going to file a motion or you're not. But I'm just not going to sua sponte start looking at things. That's not the role of the court. Parties bring the court issues to decide and the court makes decisions. Otherwise, I'm going to go ahead and schedule this for a trial and we're going to go forward, because as of right now, I don't have any legal basis and nobody's provided me with any authority or any kind of motion for why Mr. Bach, why the case shouldn't proceed against him. So this case has already been delayed for 30 days, Mr. Norton, because you weren't here at the last status conference. So I'm going to give you a short timeline here of 30 days to get a motion filed. Obviously, it won't be set for hearing within that 30 days, but you need to get a motion filed within the next 30 days. Any kind of motion that you want to file that you believe relates to this case being able to proceed against Mr. Bach, whatever basis you have, again, needs to be filed within the next 30 days. Once we have a date for hearing on that, the court will set it for another status conference on the same date as the hearing on the motion. If no motion is filed within 30 days, I am going to get trial dates on the calendar for this case. So if the court doesn't grant any relief with regard to Mr. Bach, that we have a timeline for proceeding. So Mr. Fico, in terms of trial dates, how far out would you like the court to set those? And on behalf of plaintiff, how much time do you think that we would need to set aside for that?
I don't anticipate it taking very long, Your Honor, a half a day perhaps. I don't know what the court's docket looks like. I do have some vacation coming up in the middle of January that I would like to keep open. So you know, anything that doesn't conflict with that. So maybe at end of January or.
Okay. All right. Mr. Norton?
Well, if we're talking 30 days from today to file the motion the court has now made mention of, I don't have any trouble with a hearing date afterwards, anytime January, February.
Okay. All right. I think realistically, based on the court schedule, it's most likely going to be February. So Mr. Norton, do you agree with the half a day?
I would say 1 day. I mean, not a half day, but I would say 1 day. Not that that makes a big difference.
All right, so the court will set it for a 1-day bench trial, and that's going to be about 90 days out. I will put in the scheduling order, any motions, dispositive motions on behalf of Mr. Bach need to be filed within the next 30 days. And then the court will set this also for a pretrial status conference immediately prior to the actual trial date to address any issues regarding procedure for the trial.
If I do have some more vacations scheduled in the middle of February as well, so or I guess early February or late February for me would be best.
No opposition here.
Okay, all right.
In your honor, if I may?
Yes.
May I be excused from further hearings?
Sure. Yep.
I don't know if you want to put that in your, I don't know if that would go in your order or not. I don't know if council's agreeable to it, but I don't want to keep spending receivership money, your honor.
Yes, certainly plaintiff has no objection to that and no, it's never taken the position that the case is anything other than stayed according to the, as to the 45-degree hospitality entity. So absolutely no objection here.
Yeah, I think, Ms. Wilson, the way our register of actions, when somebody files an appearance in any capacity, it automatically generates notices of hearing. So unless we purposely exclude that, so we'll make sure that we do that going forward.
I appreciate that, Judge. Thank you very much.
All right, Mr. Fico, any other scheduling dates I can address for your side today?
No, thank you. I think I can make whatever other dates the court picks, I can make them work.
Okay. Mr. Norton, anything else I can address for your side today?
I'm anticipating a forthcoming scheduling order from this court with respect to items discussed today.
Exactly. Yes, sir.
Thank you.
Okay. Thank you. That's all for today. All counsel are free to disconnect at this time.
Very good. Thank you, Judge.
Okay, let's see. This is the matter of Amber Mberg versus Loretta Mberg, case number 2419754. And if I could, let's see, have you both unmute. And I have this set as a date to enter a final judgment of divorce in this case. Amber, you are the plaintiff. Is that how you wanted to proceed today?
Yes, sir.
And Loretta, is that how you wanted to proceed as well?
Yes.
Okay. All right. I'm going to place you under oath, both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking each of you today are the questions that I'm required to ask to establish grounds for divorce under Michigan law. So if you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes. Yes.
Thank you. You can both lower your hands. Amber, I'm going to start with the questions for you since you are the party that filed for divorce in this case. When you filed for divorce in this case, Had you been a resident of the state of Michigan for at least 180 days?
Yes, I have.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
In this divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Do you own any property together with Loretta?
No.
Are there any issues remaining regarding the division of assets or debts of the marriage for the court to decide?
No.
Thank you. Loretta, did you hear all the questions that I asked Amber?
Yes, I did.
And did you hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers she gave were untrue?
No.
Under this divorce, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Are you currently pregnant?
No.
Do you agree that you've divided up any property or debts between the two of you and that there remain no issues for the court to decide?
That is correct.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I'm signing the judgment of divorce with today's date. Loretta, are you asking to have your last name changed?
Yes.
Okay, and that's to Monusko, M-O-N-U-S-K-O?
That is correct.
Okay, so from today forward, because the court's entering this judgment of divorce today, your name will be legally changed. So you'll need to make sure that you change your identification or other documents.
Okay.
And if either of you would like a copy of this judgment of divorce for your records, and Loretta, you're probably going to need that to change your name if you need to change your name. That's available for you here at the courthouse in Gaylord downtown.
Okay.
Do either of you have any questions at all?
No. No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you. All right. Thank you.
It also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.